Marvin's on his way, but he's tied up in traffic.
He called just then. He's in that big wreck down there at Charlotte.
Yep.
All right. I'd like to call this meeting to order of the Tennessee Auctioneer Commission. Donna, you want to do the roll call?
Marvin Alexander.
Rick.
Here.
Gary Cunningham. Jeff Morris.
Here.
Howard Phillips.
Here.
Mr. Chairman, you have a quorum.
Okay, would you like to read your notice of meeting?
I will. This meeting's date, time, and location have been noticed on the Tennessee Auctioneer Commission's website, included as part of this year's meeting calendar. The calendar was updated on February the 1st of 2013 to reflect the new meetings. Meeting has been posted on the Tennessee Auctioneer Commission's website. Microphone's cutting off and on, but
Be a little closer.
if you, when you do speak, make sure the red light is on your microphones.
Oh, yeah.
I think we were muted. All right, do I hear a motion to review? Has everyone had a chance to review the agenda?
I have your, Mr. Chairman, and I move that we adopt the agenda for today.
Second.
All in favor?
Aye. Chairman, I've reviewed all the minutes, and they seem to be in order, so I move that we adopt the minutes as written.
All in favor?
Aye.
All right, looks like first on the agenda is a public automobile auction application to determine eligibility.
Chairman, I'd like to make a motion that we
Marvin gets here.
Marvin gets here.
Marvin's on. We hadn't heard from Gary. Wait till Marvin gets here to review the public automobile auction application.
Second.
Press, looks like you've been moved up.
Good morning. I'm Ressa Hansen with Nashville Auction School. And first, I would like to report on the state seminar. We do have a seminar scheduled for Monday, May 20th at the Ward Agricultural Center in Lebanon, right off I-40. And that will begin at 9 o'clock. We're doing 2 hours of selling firearms at auction and 4 hours on contracts in the Uniform Commercial Code. So, Mr. Chairman, we will also have a newsletter coming out in June. So I'm giving you lots of advance notice.
Articles,
yes. Yes, please.
Being the prolific writer that you are.
Yes.
So that's my report on that. And then I also have kind of switching hats. If y'all have any questions about the contract or our role as a contractor, I'll take those now before I switch hats and give another report. Last month, in the month of April, I served on a subcommittee for the Ohio Auctioneer Commission. And had mentioned to this commission that I would report to you after that meeting. The Ohio board was solicited by an auction school to approve basic auction education by distance and teleconference. And what they did is they put together a subcommittee of auction educators and had us all get together and discuss the pros and cons of that. So the outcome of that meeting, which was held on the 15th of April, was that Ohio is not going to take any immediate action to authorize basic auction education by distance at this point, but what they're looking at is maybe some distance prerequisite requirements or opportunities. They don't require CE in Ohio, so most states that do require CE do allow distance education for continuing education, but nobody's allowing it for basic at this point. So there's no action on the part of the Ohio board at this point. So do you have any questions regarding that? And then the third part of my report is my visit, also in mid-April, to the Kentucky Auctioneer Licensing Board with regard to the Kentucky Core CE requirement. They, I have notes. Let me read my notes. This last board meeting, this board requested that I convey to the Kentucky board your concerns about their core requirement. What they have is they have a written course that covers specific topic areas that are specific to Kentucky law, contracts, warranty of title, ethics, and escrow. And so when I went to that board as an education provider, our initial concern as Nashville Auction School was because we offer continuing education courses that cover those core topic areas, would the Kentucky board accept, for example, a contracts course that they had approved to meet that core requirement? So that was one part of my visit to them. And the bottom line is they are very fond of their core requirement. And their state law authorizes their board to establish a core continuing education course and requirement. And their position is that they have operated in the legal responsibility of their board, and they like the course that they have produced. So the answer is kind of yes and no. The answer is because Indiana has a core requirement. Indiana requires 16 hours of continuing education over a 4-year licensing period. And their continuing education requirement stipulates that 6 of the 16 hours have to be obtained from those core subject areas. But they don't mandate a specific core course. There is an education provider that has a course called the Indiana Core Continuing Ed course, and there apparently was some confusion on the part of the Kentucky board that that was a board-sanctioned course, which it is not. But the general gist of it is that they want all licensees to have their core course. What I did report to Kentucky was, as far as this board was concerned, was that the Tennessee Auctioneer Commission had requested that I express to that board your concerns about the Kentucky Core course, and that you had instructed legal counsel to investigate the options of an additional CE requirement for Kentucky licensees. They did not particularly embrace that, and basically said they were not going to change their position on the core course in any way, shape, or form, and that they were acting from their perspective in the best interest of the Commonwealth of Kentucky, and they trusted that y'all would act in the best interest of the state of Tennessee.
We got that message.
Just liable to be in the best interest of the state of Tennessee that we require that too.
That's my report.
Thank you.
Thank you.
I have a question.
Yes, sir.
If you are required to do that Kentucky Core,
We are an approved provider to offer that core, and Commissioner Phillips, I don't know if your children have told you, we are offering that on the on the 19th of this month at your facility.
oh,
So we will also be holding one in Tullahoma in June. So we are an approved provider for the core. We have submitted that for continuing education credit for Tennessee credit. So any Tennessee licensees that have to take the Kentucky core can also get credit for Tennessee CE. I haven't received a course code, so I don't know if that's been approved yet or not. I didn't have to have notes. I'm distracted. Thank you very much.
Thank you.
Rest, I will say, if you ever need a spot down in West Tennessee, call me.
Okay.
like to note that Commissioner Cunningham has arrived, and we're glad that he's here. And also that if it wasn't for Commissioner Cunningham going above and beyond the call of duty last meeting, we wouldn't have had a quorum. He came in and helped us out.
Start with the legal report. The first three matters are 2013-003681 and 2013-003-701 and 2013-003-741. The complainant states that Respondent 1, a firm, is contracted by a municipality to provide auction services, and complainant states that Respondent 1's website shows Respondent 3, Auctioneer, as its principal auctioneer. Complainant states that Respondent 1 and Respondent 3's licenses expired in 2011. Complainant further states that Respondent 1's website lists Respondent 2, Auctioneer, as an auctioneer, and complainant states that the online license lookup does not show that Respondent 2 has a license. Complainant states that there are several upcoming auctions for municipality advertised on Respondent 1's website. Responses were submitted by Respondent 3, stating that Respondent 3 had learned prior to the complaint that Respondent 1 and 3's licenses had expired, and Respondent 3 is already working through the necessary steps to reacquire those licenses. Since the date of submission of the responses, Respondent 1 and 3 have obtained active licenses. However, Respondent 3 states that this fact is irrelevant to the allegations within the complaint, as the only business which Respondents 1 and 3 have been engaging in since prior to license expiration is the reallocation of government property by and under the direction of a municipality. Therefore, Respondent 3 states that the exemption found at Tennessee Code Annotated Section 62-19-103, subsection 3, applies to Respondents 1 and 3. Therefore, the complainant's allegations are without merit. The relevant exemption states that the provisions of this chapter do not apply to, and subsection 3 states, any auction conducted by or under the direction of any governmental entity or pursuant to any judicial order or decree. As to Respondent 2, Respondent 3 states that Respondent 2 is a licensed auctioneer and has overseen and assisted with the municipal auctions with Respondent 1 for several years. There's no information indicating that any other types of auctions were being conducted other than those for the municipality. Additionally, Respondents 1 and 3 are now active licensees. However, it is recommended the Commission discuss whether the exemption found at Tennessee Code Annotated Section 62-19-103, subsection 3, extends to this situation, and the recommendation on that is to discuss this this exemption, this particular exemption. My first thought when I was looking at this, the way it's worded is that any auction conducted by or under the direction of a governmental entity. My first thought was, well, this seems to cover it. However, I wanted to discuss it all with you because I know you all being industry members, for the most part, you might have other feelings, and I thought it was worthy of discussion because sometimes these exemptions aren't drafted as well as we would like, and there was no annotations and there was no case law that I could find that further expounded upon this, and so that's why it's open for some discussion right now.
I believe it happened in my area, didn't it?
Yes, if you might want to recuse from the vote if you think you're familiar with the facts. Okay.
Explain to me what took place here, because
What happened is the first person here, and I know it's hard when it's anonymous, the first respondent listed here was at one time a licensed firm. The firm license at the time of the complaint was expired and had been expired for, I believe it was about a year. The same thing goes with regard to Respondent 3. Now, the complaint against the Respondent 2, the person seemed to just be saying, I don't think this person's licensed. We have an online lookup where you can look through the state of Tennessee, and he didn't think that person was licensed. That person appears to have always had an active license. Since the time of the complaint, both of these individuals, 1 and 3, the firm and the individual who had the expired license, have have regained active licenses. In the meantime, they claim, and I could find no indication indicating otherwise, and the complainant did not claim that they were doing any other auctions other than for this particular municipality. I think it was for seized items. I may have to check my my files, but that appeared to be the only one. And this person claims, I'm reactivating my license, indicated wanting to expand the business beyond that, but believed that they fell within the exemption for doing those type of auctions during that period of time.
I agree. I think that they fall under the exemption for doing it for a government. But if their ads are running as ABC Auction Company, and ABC Auction Company is not a licensed company, to me that's an advertising violation. And even though they're selling it something that's exempt, if it was just Joe Jones and I'm selling this stuff for the government, okay. You see what I'm trying to say? Because if they're advertising themselves as a company and they don't have a license, then that's still false advertising, no matter who you're selling for.
There weren't any advertisements submitted, but there was a website. And I don't know what that website said at the time, back when this complainant submitted the allegations. At the time that I got it, it was time to review it. It was a licensed firm.
There were some ads run.
There were some ads run. Okay, none of that was submitted to me. And on the back end, sometimes it's hard to obtain that. It was a very short complaint, and there weren't a lot of documents submitted, so I did not see those.
If you run ads and you don't have an auctioneer license and you run ads as you have,
Even if the sale really wasn't illegal because it was selling it for an exempt entity or whatever, it's still illegal, misrepresenting.
The bottom line, and I understand your concerns, and they make sense. These people are, I do want to point out, active licensees again, so this might be something we might consider a letter for, if you all would like. I think Respondent 2 always had a license. That appeared to be a misunderstanding on the license lookup, but 1 and 3, we could do a letter of instruction or a letter of warning regarding, I guess, our advertising rule, perhaps, or actually 6219-102, subsection 1 states that it's unlawful for any person to act or advertise or represent to be an auctioneer, apprentice auctioneer, or firm without holding a valid license issued by the commission under this chapter or prior state law. We could include that.
I think a letter of instruction referring
and then
to
maybe
that.
parts of the advertising rule about misleading advertising.
excuse me.
Oh, Marvin, you're right over here, buddy. Right over here. And that is the issue, Julie, that they need to understand that while they want to hide behind that exemption under the law about holding an auction, if the city advertises we're going to have an auction and they show up and do the auction, that's one thing, but when they advertise that this company is holding an auction for the city, that takes them out of that box. So they can't hide behind it at that point in time.
To me it does, yeah.
This is a case of after you get caught, you can make it right.
A letter of warning, perhaps, instead of a letter of instruction. Okay. Would y'all like to do all this in the form of a motion?
Form of a motion.
I'll make that in a motion, that would be the letter.
A letter of warning regarding that statute I read, and then would you like me to also include information about the advertising, about misleading advertising, or do you think that statute covers it pretty well?
I'd like for you to add that too.
Evidently, they don't know that.
Yeah, I'd like for you to add that too.
All right. Letter of warning, you said. To 1 and 3. Okay.
Because 2's been licensed all over. Do I hear a second?
I'll second it.
All in favor?
Aye.
And I have to abstain.
We'd like to thank Commissioner Alexander for fighting the burning tractor trailer on I-40 and making it.
Would you all like to go back to the application and continue the legal report later? It's up to you all.
We don't want to do, what's the,
There's 2 more on the legal
we're
report.
just going to.
Okay. Okay. Number 4 is 2013-007-171. I'm putting in the summary from the April 2013 meeting because you all had instructed this complaint to be open based on this. In April 2013, at that meeting, there was a complaint summary for a licensed gallery. This is a related complaint. I'm going to read it to you. The same complaint mentioned above. It was numerous complaints. Also stated that respondent, a gallery, did not use a licensed auctioneer, but the complaint did not provide the name of any unlicensed individuals who called auctions for respondent. The owner of respondent, this is the licensed gallery that their original complaint was against, submitted a response stating that respondent has a permanent auctioneer and provided the name and license number of the individual who is an active licensed auctioneer. Respondent's online auction ads all appear to confirm that this licensed auctioneer is the auctioneer for respondent. When that auctioneer is not available, respondent's owner states that the auctioneer sends another licensed auctioneer to take his place and call respondent's auctions. On one night, a few days before the complaint was submitted, respondent's owner stated that the regular auctioneer was called away on an emergency and told respondent that an unlicensed individual could call that night since respondent was selling all of that individual's items that night. Respondent's owner states that if they were in the wrong on that occasion, they were unaware, but in all other instances, respondent has used licensed auctioneers. Respondent's owner indicates familiarity with complainant as a fellow industry member who has an auction who has attended respondent's auctions. The recommendation at that time was a letter of warning to the gallery regarding using a licensed auctioneer to call bids in all auctions under Tennessee Code Annotated, Section 6219-125B, and the exemption found in Tennessee Code Annotated, Section 6219-1035, for any person performing acts relating to property owned or leased by the person. The decision at last meeting was that the Commission voted to authorize a formal hearing with authorization for the respondent to settle by consent order with a civil penalty of $500 for using an unlicensed individual to call auction bids in violation of Tennessee Code Annotated, Section 6219-112B7, and Tennessee Code Annotated, Section 6219-125B, and to open a complaint against the unlicensed individual who called bids at the auction. This complaint that I'm reading right now, pursuant to the direction of the Commission, this complaint was opened against respondent, the unlicensed individual, for unlicensed activity, and a copy of the complaint was sent to respondent for a reply. Respondent submitted a reply stating that respondent called the auction on a single occasion because the auctioneer, who is a personal acquaintance, was called away on a family medical emergency at the last minute, and respondent was selling only what respondent had consigned to the auction for that night's sale. Respondent states that respondent graduated auction school in the 1980s in another state and for a while called auctions in another state prior to moving to Tennessee. Respondent states that respondent tries to do the right thing and did not intend to break any rules, but in this particular situation, respondent was attempting to help and thought respondent was doing the right thing. Respondent stated that respondent sold only property which respondent had acquired over the years, such as tools, toys, and glassware, which respondent had possessed for many years and no longer had space for the items in storage. Because respondent called only one auction where respondent's personal property was sold, and because the information indicates that the property sold was not acquired by respondent for the purpose of resale, it appears that respondent falls within the exemption at Tennessee Code Annotated, Section 6219-103, subsection 5, and therefore the recommendation is to dismiss as to this individual. Yes, he called the auction that night. It was all items that were his property that he had brought up there to be sold that night.
It was his own property.
It was, and when I spoke with the gentleman, I asked him the nature of because it wasn't directly addressed. I said, I have some concerns here. What kind of property was this? When did you acquire it? Had you sold before? And he said, you have to understand I have a 20 by 20 garage. I have toys. I have kids that are going into college that I need to get rid of. My wife had some glassware that she'd had for 25 years. I just don't have space for it. So from time to time, I take items up there. This one night, they needed somebody to call. I was told I could call, and I did it. There was no indication submitted by anyone else indicating otherwise, and that's why when looking at this exemption, it appears that this personal property was his and was not acquired for the purpose of resale based on the information that I was able to obtain and that was provided to me. He said it was a one-time thing. It was a child of the auctioneer that was called away on a family medical emergency. There's sometimes no way to verify that anyway other than calling the person and talking to them, which is what I did in this case.
Number one, in my opinion, the auction should have been postponed because this is fine, and I'm fine with it. But what if somebody had got beat out of $5,000? Would we be sitting here and saying, oh, well, that was fine because it was his stuff?
Well, the way and I could be incorrect, the way I'm looking at the gallery license, because this was a licensed gallery where it was being done, the gallery license statute states that the gallery license holder may sign the consignment agreements, issue the closing statements, and collect and disperse funds. Those people, I understand, have received education, and that this man was just calling. He was not handling the money. That's the information that was given here. He was not the one collecting and dispersing.
He was the auctioneer that night. He had get license, and auction because you.
But there's no. I'm sorry. But there's no proof that he auctioned anything other than his own property. So.
Is to dismiss.
I make a motion.
Second.
All in favor?
Aye.
No.
We have 4 ayes and 1 no.
All right.
I've been requested that we go back to put you off for a minute, Julie.
Okay.
Back to the public automobile auction application. Now that we have everyone here.
Tab 2.
Yes, if you'll turn to tab 2 in your tablets, there are oh, okay.
If you
And the answer was if I wanted to go.
Copies of Mr. Jerry Bowman's application for a public auto auction in Shelbyville, Tennessee, by the name of Mid-South Public Auto Auction and Special. Bowman is here if you need to ask questions of him. There are copies of all of the licensing requirements in your packets. Insurance, bond, garage keeper's liability insurance, a financial statement, minimum net worth, a business tax license, and proof of his motor vehicle dealer's license.
probably wouldn't be a bad idea. in case we have any questions.
I have a question for Mr. Bowman. On your balance sheet, you're showing your net worth of being $100,241, barely breaking the net worth provision of the law. But it shows no cash. Is there no cash in the company?
I turned everything over to, certified CPA that done all this, what I was required to do, and
And this is a balance sheet as of November 30th, but you don't have a current balance sheet.
it says within, done it last year. I mean, I started out this process in December, November when it started, and I've been following all the stuff and getting all the information together to this point.
You don't have a current balance sheet.
Well, that's as current as, yes.
That's as current as you have.
Yes, sir.
Is your calendar year, is your fiscal year in November 30th, or is it fiscal year 12/31? 12/31. Okay.
I have a question. Do you have a Tennessee auctioneer license?
No, sir. I'm not an auctioneer. No, sir.
Art Parker has the one that's going to school.
Yes, sir. He took his 30-hour class a couple of weeks ago, and that's going to be my auctioneer.
Or the company. So I'm sorry, Howard.
My question was, are you the sole owner of the company?
Yes, sir.
Okay. Excuse me, what business have you been in up until now?
I've owned and operated Bedford Quality Fencing for the last 25 years in my town in Bedford County in Chevyville, and I've never had a legal action or nothing against me conducting any business whatsoever. I'm in good standings with all the commissioners and everybody in my town and stuff, and they're very supportive of me, and I got a good track record. And
Well, I'm sure you do, but this public automobile auction is relatively new, and you've heard some of the questions that I've asked since we've been in this meeting already. But I attended every meeting on the Hill when public automobile auction license was being passed. And the one thing that I distinctly remember is that you must be a licensed Tennessee auctioneer, have 30 hours of public automobile school, and that you take every title and sign your name to it after you sell it, take possession of it. And, Gotta have every car checked to whatever that check is. What's Carfax. I mean, there's a lot to it, but the part without a Tennessee auctioneer license, I don't see how you could get a public automobile auction license.
I'm hiring a public auto auctioneer that's took his 30-hour endorsement to be my auctioneer to.
Is your apprentice auctioneer, in your opinion, he's going to sign off and be responsible for every automobile you sell? He's going to be responsible for every title that comes through that building?
Yes, sir. We're going to have.
No, sir, I'm saying, is your auctioneer going to do that?
In whatever we need to do there, yes, sir.
He will be if you get this license, he would be solely responsible for your public automobile auction.
Yeah, yes, sir. If he needs to sign every title, that's fine.
Take care of the money.
I don't believe that he could auction off a car and take money for that vehicle all at the same time. I have clerks.
Be responsible. Be responsible for the money.
Okay.
That's what was confusing me was I'd always read the law that the auctioneer that was the auctioneer of the firm, Mid-South.
Well, there's 3 commissioners or board members here that have been to the 30-hour public automobile auction school. 2 of us have public automobile auctions. I'm not against. Don't get me wrong. I am not against public automobile auctions being in. I think the more we get, the more, the better it's going to be. But I just have a question about an owner not being an auctioneer. That's my question. I'm almost positive in the 30-hour course we took and the bill that was passed, you have to be a Tennessee auctioneer license.
The problem being we've looked at these statutes and rules. We don't see that clear cut. These rules don't clearly seem to state that. There was also an Attorney General opinion that does not appear to clearly state that. And when going back and looking at the history of the licenses that have been granted for public automobile auctions by this commission, the information on the applications indicate that 3 public automobile auction firm licenses have been granted by this commission for firms that do not have a public automobile auctioneer as an owner. And that's just a source of, by going back and looking at the applications and the information that was submitted at that time. First one, Dealer's Auto Auction of Murfreesboro, LLC. The owner listed on the application is David S. Andrews, and the principal auctioneer, who's the public automobile auctioneer, is Austin C. Notgrass, who is not listed as an owner on the application. The second is Bidmore Auction, LLC. The owner listed on the application was John Edwards, and the principal auctioneer and public automobile auctioneer was Rodney Settles. The third was Acacia Chattanooga Vehicle Auction, and it's a DBA and it cut off, but I've got the application here. There was a J. David Bynum listed as the owner on the application, with a Joseph D. Vanover listed as the principal auctioneer, and public automobile auctioneer not listed as.
I remember the Bidmore one because Edwards come up here and lied to us and told us he owned part of it and was in school. I remember that one, of course.
Now, Julie, are those dealer only, or are they public?
These are public.
These are licensed public automobile auction firms.
You said Mr. Rod Settles, and what was the other guy's name?
For Bidmore,
Yes.
the owner was listed as John Edwards.
Do you know that did they ever have an auction?
I don't know that information. My information was obtained by going through the applications and reviewing those with staff.
They did, Commissioner.
And that's not the end of that story, but okay.
Well, there's a long story with Mr.
I mean,
Edwards
not by
and
any
Mr.
means.
Settles.
And it might have been better if they had been straight.
Other two, I don't remember them.
I wasn't here.
I understand what you all are saying with what the intent was when this was drafted, but when we look at the finished product of this statute, and even the Attorney General's opinion, it's hard to point to a provision that specifically states.
Did the Attorney General state that you do not have to be a Tennessee auctioneer to have a public automobile auction? Is that what he said?
Did he say something to the effect that auction is not a person, it's not an entity, basically is what he said.
He said that a public automobile, and I'm just reading just a section of this is not the entire thing, but a public automobile auction is the means or process of offering motor vehicles for sale to the highest bidder. It is an act or event, and thus by its very nature cannot be owned. If you can go from there, there's no specific statement saying you do or don't that we can glean from this Attorney General's opinion. And keep in mind, this is an Attorney General's opinion. This isn't a law or a rule either, but it doesn't appear to specifically address this either.
But he didn't say that you didn't have to have a license either. That is about as vague since that opinion came out as anything I've ever seen. I mean, to me, it says nothing.
You're correct. It does not state specifically one way or another. I'm just telling you that in reviewing the statute, the rule that we have from the statute, which was approved by the Attorney General's office, and this Attorney General opinion, which is all we have to look at this point, there does not appear to be that clear requirement there. It doesn't appear to clearly not require it. It just does not clearly address this. What we have is a rule that does not specifically speak to this issue. That's why we went back and looked at the history of what appeared to have been approved in the past.
Did you go back and read the law as it was passed in the Senate and the House? That what you do and what you don't do, and I know the Attorney General's opinion was asked for, but it was not specifically to see if you had to have a license or not. That opinion was for something else.
Well, one of the questions in the Attorney General opinion is the requirement that the public automobile auctioneer also be a licensed motor vehicle dealer satisfied where the public automobile auctioneer owns, in whole or in part, an entity licensed as a motor vehicle dealer. So it does appear to address that. But no, we're looking at the final statute that we have to go by that's on the books here, something we can point to.
I'd like to add something, if I could, to this conversation. Before Mr. Bowman filed this application, he called our office and talked through all of the licensing requirements that he had obtained. over the phone, and it was determined, or he was told, that it requirements they went over are under 6219-128. The minimum or in there does it say that the owner of the auction also hold a public automobile auctioneer license. Only received a few of these applications, and I bring them all to you, and it seems like we go through this argument every time.
Does it say anything about where the owner has to attend the class?
Automobile auctioneer that he told us he had hired.
If you, underneath our licensing statute 6219-111, it says any individual, are you talking about the requirement for somebody who obtains a public automobile auctioneer license?
Or a public automobile auction license, which is what he's applying for.
It does not outline education for the public automobile auction license. 6219-111 outlines the requirements to obtain the education requirements to obtain the license as a public automobile auctioneer, which means that they shall have reached the age of 21, served as an auctioneer for a period of 2 years, and successfully completed, in addition, the education provided by A2, which is for the auctioneer, 30 hours or more of rigorous classroom education in automobile auctioneering approved by the commission. That's for the public automobile auctioneer.
Of course, I think we thought that you'd have to be a public automobile auctioneer to get a public auction. Marvin, what do you think?
Could I ask one more question, because Mr. Marvin knows?
You sure can.
What, you can, where does a gallery license fit?
But I'm sorry, where does a gallery license fit?
Gallery license be required in this situation?
I don't believe so. I don't believe any of the ones do a
Do they have a farm license? They'll have to have a farm license.
Bowman have a firm license?
Does anybody have one that's doing this, or is Parker? Or
There's
Basically, this is what this is. If we grant a license, this is the license for them to conduct the automobile, for him to have a public automobile firm license without being an auctioneer. And his auctioneer would have to satisfy Section F here about retaining and taking possession to the title for every item sold at the auction.
But where's that checklist? I thought you had to have a farm license.
No, this is the firm license, if you read this statute.
Well,
I guess I overdid with paperwork when I did mine.
Well, in your opinion, you own, I'm assuming, you own the building, and you have your building and everything is ready to go for a public automobile auction, right?
Yes.
So all you're going to do, personally yourself, is the only thing I see, if this is granted, that you could do would be go in and get you a nice, comfortable seat, right?
Just being the owner, I could sit anywhere I wanted. I ain't trying to be smart, but I mean,
Yeah, well,
I don't know
that's why
what
I said
to.
you get a comfortable seat.
Yes, sir. I mean, I have no desire to be an auctioneer. I couldn't make music with a pot and pan. I mean, that's the reason why I hired Kurt.
I'm talking about assuming responsibility. You are going to assume no responsibility because this guy that has a license is assuming all responsibility. Is that correct in your mind?
Whatever we're required to do by law, yes, sir.
Took your information to your accountant. Did you give him appraisal on your building, or is that just?
Accountant's always done my business and stuff, and it's a public accountant to, by the laws, I mean, she's a public accountant, and
Oh, I'm not questioning it. I'm just asking, who set the value on your property? Did you give her that, or was that an appraisal?
I don't know. I mean, I got appraised value on it. I mean, I didn't see where that was a requirement. I mean, I just went down the list and took all.
Necessarily a requirement. The only thing is you got to have the $100,000 net worth. If the building happened to be worth 100, and I'm not saying it's not.
Oh, yes, worth a whole lot more than that.
That's what I said.
They got it on the balance sheet at $250.
Yeah, I saw that. But what I said, was that just a value that was turned in?
Actually, I got appraisal on the building, $455,000. Okay.
Personally, I don't see how since the other 3 licenses have been granted, that it would be right to disallow this one. However, there needs to be some way that we're satisfied, or that he understands that, and the auctioneer understands that he's going to, and he's going to have to do the paperwork. The way I see this law is written, it won't be a deal where you can go in and run the business like you'd normally do, and he show up sale day and auction. He's got to do all the other 2. Is that not right?
The cars come in to be checked in. The auctioneer is going to be responsible for those cars, getting them the title Carfax, selling the car, paying the people for the car.
Sir, I've been to several public auto auctions myself, personally checking them out, looking their rules and their regulations and everything, and stayed there for the whole entire time. And I have yet seen an auctioneer yet out on the floor checking in a car or writing out a check or doing any paperwork. The only ones I've seen the whole time, they auction a car off when they come through the thing. But, whatever I have to do by law, I mean, I don't want to break no law. Whatever I have to do would confound the law to do this business, yes, sir, I'm all for it.
The point that we're trying to make is that it's the commission's, the only place that we have any jurisdiction is over auctioneers and on the auction process. And we are dead set for making the auctioneer responsible. And that is the principal auctioneer. I'm the principal of my firm. No matter what anybody on my staff does, all the responsibility falls on my shoulders. And the same thing is going to be true for any company that we license, that we want to see a person, a human being, that we can say, this is the person responsible for any and all actions of this company. That's why we have the principal auctioneer written into all the rules. We're going to go through some rule changes today where we talk about that. And we want to be able to say to anybody who files a complaint with this commission, this, we have a principal auctioneer that we can point to. And because you're not a principal auctioneer, we can't say we can go to Jerry. We're going to go to Kurt and say, Kurt, you're responsible. Anything that happens into that company, if anybody has a dispute, they have a problem, they want to file a legal action or file a complaint with this commission, then we can go to Kurt and say, Kurt, you're responsible. What happened in this case? And then we can fine Kurt or revoke his license based on what he did, not on what you did. You're not covered because you're going to be a gallery owner, basically, or a public automobile auction owner, but you won't have the responsibility. Your auctioneer is going to have that responsibility, and that's what we're trying to make loud and clear to you under this application.
I think his license would still be on the line.
His license would be on the line, but the responsibility for any actions under that license are going to fall under Kurt.
Right.
And I think you misunderstood what I said. I didn't say that the auctioneer had to personally check in the cars and do the car fact. I said he was responsible for that. Or I apologize and tell you that's what I meant to say if I didn't say that. Now, no, one person cannot do it all, but
What does
you've
that,
got one person to be responsible.
how does that read as far as the financial statement on that law? It says it in accordance with general accounting principles or something
Are
like
you
that.
talking about the compiled financial statement? The public automobile auction shall have a compiled financial statement prepared in accordance with generally accepted accounting principles by a certified public accountant or public accountant dated not earlier than 12 months prior to the date of the application, and shall furnish a copy of the financial statement to the Commission along with any changes to the statement. Is that the one you were referring to?
Approve the license
Because-
based on what's been done in the past.
Well, but this one reads, I have not audited or reviewed the accompanying financial statement. Accordingly, do not express an opinion or provide any assurance about whether the financial statement is in accordance with accounting principles generally accepted in the United States of America. Actually says do not in there twice
Where do you see that?
That's under the letter from the
from
accountant.
the accountant.
Oh, okay.
And she just said,
Accountant, I ain't seen an account yet that I didn't have to sign a waiver that, you furnish them all the materials and everything, and they do the accountant practice and stuff, they do what they're required by law, but I mean, they go by what you give them, furnish them like the IRS. Everything we give the IRS, we're accountable for it. We turned it in. If we lie or didn't do something right, we held accountable for it. I mean,
Unless
the
you
way
pay
I'm
them-
saying, I'm just saying
Unless you pay them to do that audit.
sir,
You can hire them to do that audit, and then they can certify it.
right.
well, the only thing
I did hire them. I
About
did
whether
pay
it's-
them.
Not to do an audit of your books.
it's in accordance with accounting principles generally accepted in the United States of America, which is verbatim what the law says. And this says do not express as an opinion or provide any assurance of.
Chairman, most accountants will not do a financial statement without they do it this way.
Well, unless you hire them to do it.
Have big money to come and do a complete.
Okay, I was just asking. I ain't not sure.
Yeah, but you can hire them to do that. I second Marvin's motion.
Marvin, that we grant the.
I grant the license based on what we've been done before. We've already granted 3 of them.
Could I ask you a question, Mr. Marvin?
All in favor? All opposed? Five in favor, so.
You're approved.
Thank y'all, sir. Well, could I ask y'all a question? Which 2 of y'all got a public auto auction? Okay, I didn't know. I just asked. Sir?
I'd like to have one.
Which?
I don't know.
That's what I went to school for.
But thank y'all for your time, and I wouldn't try to be smart with y'all at all.
Mr. Bowman, I will caution you that we meant what we said about your auctioneer needs to understand the liability under which he's operating.
Jerry, if you have a question, I don't know all the answers, but you're going to have some questions. You're going to run into some snags, and you're going to run into some problems. If you'll call me, I'll help you. Okay?
Where's your auction at?
Knoxville.
Not, is it, what's the name of
It's auction and realty public auto auction.
it? Kyle? I've been up there.
You been there?
Yes, sir.
Good gracious. I would have thought I would have remembered you.
I've been there, sir.
Was you undercover?
I got all your literature and all on everything.
Well, just good luck, good luck, and.
Well, I'm sure some bumps up and down the road, sir, but I'm going to do the very best I can do.
The very best place you can come to buy cars is right there where you was at that day.
Some of
You
these
can buy
guys
some and sell them.
has been bad news. Now, before we finish legal, I would like to take a break.
Hey, it's hard to back up when you're done three.
I guess we're back to you, Julie.
Okay.
Could I go back to the public auto auction and ask a question?
You certainly may.
Now, as it stands now, to have a public automobile auction, you can only hire auctioneers that have a public 30-hour public automobile auction course. Okay? That, in the Attorney General's opinion, could be, you wouldn't have to do that?
The Attorney General's opinion states in part that the auction event has to be arranged, managed, or carried out by a licensed public automobile auctioneer. So that is stated there in the Attorney General's opinion. And the statute contains requirements. You know, I think you referenced some of them during the discussion of the public automobile auctioneer taking possession and retaining title, things of that nature. The statute outlines the duties of that public automobile auctioneer and does not relegate those duties to anybody other than that licensed individual. So.
Could that be changed by rules?
We can't change a statute by rule. That would have to be done by amendment to the statute. We can work within our own rules. Our rules can expound upon statutes, but I don't believe, and I might have to defer to the chief counsel that knows a little bit more about rulemaking than I do, but they can't conflict with the statutes. Our rules are done to expand upon the statutes. We can't do anything about the statutes themselves by rule. That would have to be done by amendment.
It's not part of the rules, but we could take that position. You know, somebody would have to challenge us in court if we took that position. You know, we might lose it, but we could definitely take that position if we wanted to.
We want to take this up when we talk about the rules in a little bit. Okay.
What I would like to see happen is for this to be cleared up. This is unfair to the commission. It's unfair to the people who are teaching the school. It's unfair to our wonderful attorneys and Donna Hancock and her personnel. There can't be another law in the state of Tennessee or any other state that is as clear as this one. It's as clear as mud. And whatever we need to do, I mean, we got a gentleman back here that's drove from one end of this state to the other one and did no wrong on his own. He was doing his homework, and it was hard for him to have to come down here and go through what he had to go through with. That shouldn't happen. It should be as clear as you've got to be a apprentice auctioneer for 2 years, you got to go to school for so many hours. So what do we need to do to correct this wrong? And I'll go to work.
Just have to change the statute.
I think we need to start with the statute.
Yeah, you'd have to change the statute.
And then
Hey,
we
does that start next January when they meet? Okay. Would you have something ready when they go and go with me
Well,
and get it changed?
we have to go through a process through our administration. I will discuss that with Michael. You may want to speak more on legislation. This is Michael Driver. He's one of the, what's your title now? Chief
I'm
Deputy.
Chief Counsel.
Chief Counsel.
Nice to meet y'all. Hope you're doing all right this morning. If you're interested in trying to pursue this statutory change, what we'll need to do is you all, I guess, get together what you'd like to propose, get it to Julie, and it'll get run up through the chain to be proposed with the next session, or at least to get looked at in that vein. So, I mean, if you all want to get together, I guess what you'd like to see done, I think that would be a good place to start. I do think right now it's in a tough place. It's hard to, as you noted, interpret the statute because, I mean, it's hard to figure out exactly what is required when you do. You know, it's still more than a little unclear. So, I think that would be the best place to start if you all get.
Do you, the way this law was passed to begin with was we went to the senators and the House members. We can't go get a senator and a House member to take this bill for us and get it corrected without going through.
There's nothing that prevents you from discussing issues with.
That's what I'm asking.
No, there's nothing that
There's nothing
prevents
that
that.
prevents that.
Individually, but not as a group.
Right, right. I mean, if you, Commissioner Phillips, wanted to talk to some industry members and a member of the state legislature, then you can do that. But if it's the commission together, then you have to do it obviously in a formal hearing and open meeting. But you could go. But if you want to make a formal
All I want, and I
request,
thank the commission and I thank Donna for her sake. I saw her squirming today when I'm fixing to say something. Because she don't understand it. I understand it. I was there. And this is absolutely, Mr. Hanson was there. This is absolutely not what it said.
Well, I understand what the attorneys tell me.
I understand.
And you know that this has been a misunderstanding, misinterpretation, or maybe it's hard to get a, yes, this is exactly what the statutes say, and we're going to follow that and nothing else. Because of that opinion, it's some of it is so vague, and the statutes are a little bit vague. So you keep talking about he couldn't do anything like transfer title. Do that on under his motor vehicle dealer license? Certain things.
Our lot. You got a fencing company. You got an automobile lot too? I didn't. When I asked you what you understand that, but how long have you been the dealer? That's my last question. I'm getting off this subject.
To answer your question, Commissioner Phillips, the commission could decide in an open meeting, we're going to talk to somebody at the legislature, and then one person can go talk to them. Or you could do it whenever. You could do, whenever. If you want us to present it, then what Michael was talking about, we have to present it through the chain of command for the legislative package that I think goes to the governor's office.
That's correct.
Yeah.
In your opinion, how long would it take?
Well, as you said, I mean, the legislature's not back in session here for whatever that is, 7 months or so. So, I mean, I don't see any reason that something couldn't be reviewed to be part of that package for the next session. On the other hand, the next session's a pretty fair amount of time away from where we're at now. No help in that.
But if the chairman says that, then that would eliminate us from going and talking to our senator, our representative.
So far as what you do in your personal capacity, talking to your representatives, I guess that's a decision for you to make. I would encourage you, though. I think in these things, it's generally better if things go through a unified front and we have one specific idea to the extent that you all agree that there's something you'd like to see presented. I think it's better if that's coming from one place at one time, so it's very clear exactly what you all are trying to accomplish with that change.
Like to entertain a motion to do that, or?
I'd like.
Have to have some language to
time.
propose too as well.
I think we've got some time to, develop some thoughts on it. You can give me some ideas, and as I understand it, when we've done legislative proposals in the past, it hasn't been where I draft up specific language. It's just a description of the things that you would like to see changed, and that may take a little time, but I can put that together, and you may have other recommendations by the time it comes time to submit those.
My feeling is I think that whoever owns it needs to be a principal auctioneer. I mean, I just really think.
And I think whenever we first did it, that was totally our intent.
It's law.
It just got
lost in the shuffle.
lost in the
Right.
shuffle somewhere.
It's the law.
All right, Julie, would you like to carry on with your?
Let's have one more on the legal report, and then we'll talk.
Thank you for coming.
I just have one more on the legal report, and this
Hey,
is
you all, Miss Julie. I'm lost.
three. It's at the bottom, starting with number 5. The actual summary will start on page 4.
Where's our little pads today?
Would you say?
Our little pads.
I don't know. I'm not in charge of those.
Thank goodness.
I don't know how to work them.
It's because of moving today, and we didn't. It's a long story.
This is just fine.
I'm sorry. Next time we'll try for you.
This is just
Hide them
fine.
and keep them.
What?
Just hide them and keep them.
They'd find me. Number 5 is 2013002641. This is a matter that was presented last month, and this is the matter of the licensed gallery that we were addressing in the one before. It's at that time I presented the same complaint mentioned above. Also stated that respondent gallery did not use a licensed auctioneer, but the complaint did not provide the name of any unlicensed individuals who called auctions for respondent. The owner of respondent submitted a response stating that respondent has a permanent auctioneer, provided the name and license number of the individual who is an active licensed auctioneer. Respondent's online auction ads all appear to confirm that this licensed auctioneer is the auctioneer for respondent. When that auctioneer is not available, respondent's owner stated that the auctioneer sends another licensed auctioneer to take his place and call respondent's auctions. On one night, a few days before the complaint was submitted, respondent's owner states that a regular auctioneer was called away on an emergency and told respondent that an unlicensed individual could call that night since respondent was selling all of that individual's items that night. Respondent's owner states that if they were in the wrong on that occasion, they were unaware, but in all other instances, respondent has used licensed auctioneers. Respondent's owner indicates familiarity with complainant as a fellow industry member who has an auction and has attended respondent's auctions. The recommendation at that meeting was a letter of instruction regarding using a licensed auctioneer to call bids at all auctions under Tennessee Code Annotated, Section 6219-125B, and the exemption found in Tennessee Code Annotated, Section 6219-1035, for any person performing acts relating to property owned or leased by the person. The decision at that time was the Commission voted to authorize a formal hearing with authorization for respondent to settle by consent order with a civil penalty for $500 for using an unlicensed individual to call auction bids in violation of Tennessee Code Annotated, Section 6219-112B7, and Tennessee Code Annotated, Section 6219-125B, and to open a complaint against the unlicensed individual who called the bids at the auction. In light of the information obtained from the previous respondent, who was the unlicensed individual who called one auction for this respondent, which indicated that all items sold at the subject auction were the property of the unlicensed individual calling the auction, and said items were not purchased by that individual for the purpose of resale, it would appear that the unlicensed individual who called the subject auction fell within the exemption found at Tennessee Code Annotated, Section 6219-1035, and this respondent did not commit a violation. However, this respondent would benefit from a reminder via letter of instruction regarding the specifics of the relevant exemption. The new recommendation on the representation is a letter of instruction regarding using a licensed auctioneer to call bids at all auctions under Tennessee Code Annotated, Section 6219-125B, and the exemption found in Tennessee Code Annotated, Section 6219-1035, for any person performing acts relating to property owned or leased by the person.
To go along with the letter. We just approved one a few minutes ago.
That was for the individual who was doing it. You know, we didn't have that information at the time that this was originally presented to you all last month, that, you know, what kind of property was this. And I think it was Commissioner Alexander that had pointed out this is not an open exemption that applies to just anybody, and we didn't have the information at the time of what kind of property it was. Based on the subsequent information we got from the opening the new complaint at you all's direction, it appears that they fall within the exemption. Some would not. If it was somebody that was going out buying things and immediately reselling them, I don't think the exemption contemplates exempting a person like that. The reason for the representation is the new information that I had obtained from that individual.
Could I ask you a question, please?
Yes, sir.
If everybody that consigns merchandise to my auction and it's only their stuff and they brought it from their house, would I be legal to let each one of them get up and auction their stuff off?
Yes, you will.
The exemption, it says the provisions in the chapter don't apply to any person performing acts in the regular course of or as an incident to the management of an investment in property owned or leased by the person if the property was not acquired for the purpose of resale. And then it goes on to state when a sales tax as provided by Title 67, Chapter 1 is not levied upon the sale of personal property, there's a presumption that the personal property was purchased for the purpose of resale. You know, it would come down to the facts of the situation. In this case, all we have is that this person did called bids for his own personal property that he had for a number of years, in which case this exemption appears to apply to him. And
the reason for my question is liability. Somebody gets harmed, is the auction company or the auctioneer, is he the one that's going to be fined, penalized, or sued, although you sold your own merchandise?
Way to determine what action somebody may or may not take. I'm just looking at the provisions of the law. We discussed this, you know, from a litigation standpoint of if that person's exempt, how can we?
Right. As far as the personal liability of the auctioneer, as far as under the auction code, I don't think it applies where a consignor auctioning their own property. I don't think under those, I mean, as far as other types of liability, I don't know as a business owner, but as far as under the auctioneer code, I don't think that there would be any liability to the auctioneer where a consignor was auctioning his or her property, and it was not, and it was property that falls within that exemption, meaning not for the purpose of resale. I don't know that it would be good practice to be an auctioneer and allow people to come in and sell their own. As far as being liable for any action they took, I think it would fall under the exemption, extending to the auctioneer. That's true. Yes,
It does say in the gallery license statute, in Part B, this is just part of it, it's a lengthy subsection, the licensee must hire a licensed auctioneer to call bids at all auctions. However, my reading of the exemption as if this, in this narrow circumstance, when someone falls under this exemption, then I don't see if we can't hold that individual, if the individual is exempted, I don't see how we can hold the gallery responsible under our laws. Now, outside of, as Mark was saying, outside of the auctioneer laws, people can bring civil actions for anything they want to. In this case, we didn't have that issue of a member of the public indicating there was any wrongdoing. This was a fellow industry member stating there was somebody unlicensed. I don't know.
About this 2 days before.
They know. When I said a few days before the complaint was submitted, the subject auction where this person called, that auction had taken place just a few days before this person filed the complaint, is what I meant by that. Is that what you're asking about?
On one night, a few days before the complaint was submitted, respondent's owner states that the regular auctioneer was called away on emergency, told respondent that an unlicensed individual would call that night since respondent was selling all that individual items that night, so they knew 2 or 3 days before.
No, what happened is, like I'm saying, on a Friday night, the auction took place, this person called it, and then this complaint was filed with our commission the following Monday morning, for example.
But the respondent's owner states that that's what that says. On the page 4.
Right, and I may have not, that was me summarizing this. I was clarifying that they specified a date. I didn't provide that date. The person said on January such and such an auction was conducted. I was just providing for the commissioners to understand the timeline here that it took place a few days before the complaint was submitted. I can read the dates. I just try to keep.
With the auctioneer. I mean, the guy's selling his own stuff, so we don't need something hanging out about the gallery, right? And that's what
I had represented it for a letter of instruction to the gallery just so that they understood clearly that this exemption does not apply across the board to anybody who says it's, they need to understand the specifics of it, I believe. That's it for the legal report this month, but we do have our ongoing proposed rule discussion, and last month we had by and large deferred this until this month. Commissioner Alexander and I had discussed a couple of issues with regard to some possible rules which are on the last page regarding livestock auction sales and clarifying a little bit of the language I had for online auctions, but those are the only changes since last month that have been done. I think we've been kind of deferring these along to have a conversation every month, it seems like. we get a little further, we make a few more changes, and then we say we'll come back to it the next month. So we're just doing this, and that is some new language that was added in there based on.
I've read through this very thoroughly after it was sent out prior to this meeting, and I agree with the changes they had written, and I think we all go ahead and adopt them and put this thing to bed.
Well, what I'll need to do is, and I've only gone through the rulemaking process once, I'll need to get these in the form of a formal rulemaking provision. I believe they have to go through the Assistant Commissioner's office for a brief review first, but I think probably what we can do is have these ready to start the rulemaking process at our July meeting. I can have them in a form ready to get this ball rolling
I would
at that
encourage
point.
you to go ahead and do that.
Does anybody else have any comments before we?
I just have one question. What, are we going to be back in the same position where it says this is going to be changed to where one to be there? Do we need in there that if somebody quits, moves, passes away, or dies, like you said, or leaves the company,
we do.
They have to be replaced.
I know we have to report it, but see, we've got one thing now about the gallery we've been having. We couldn't assess a fine because it didn't say you could, or that the license went away. If they don't report it, what happens?
Then they're in
I'm
violation.
not saying it needs.
Well, they'd be in violation of this
I understand
rule.
it be in violation, but can you do anything about it?
Well, we can open a complaint, and the commission can take disciplinary action based on
And
that.
I think we need a form where there's something comes in here where you know that somebody is that principal auctioneer. Happen if somebody's got 5 auctioneers, one leaves, says, well, I appointed Joe Blow yesterday. He's my.
I think
We already have a form where they report auctioneer leaving and then who their new one's going to be.
Okay.
They're required to give us that within.
And of course, I mean, like you said, there are inevitably going to be some people that don't do it within that period. But when we find out about it, if we have this in a rule, we have something that we can clearly open a complaint and point to. Does that doesn't seem to address your? Okay.
You know, when we get into a problem, it all gets down to where there's a gray area here. We can't do this, we can't do that.
Well, I have some revisions to the civil penalties for violations, and for what? For a
Like where you're changing it, you're adding something. So I'm just asking a question. In those penalties. I'm not saying they are or not, I'm just asking that question.
Auctioneer's license with their new gallery or firm name on it.
I think what Commissioner Alexander is asking is there a provision in the civil penalty? Don't do that the commission can take action under the rules.
And we've always tied back any violation of the rules, I believe, to 6219-112B7, which says violating any that they can be disciplined for violating any provision of this chapter or any rule or regulation duly promulgated under the chapter. And there is a civil penalty range for that of $300 to $1,000 per violation. Now, something we might could add to this, which in the most recent amendments to the Real Estate Commission's civil penalty rule, which have just come through in March, they added to their civil penalty schedule a violation of any commission rule or order, and they set a civil penalty range for that. And since this would be part of a rule, that would connect directly to a civil penalty range. That could be something we could perhaps add to this list of civil penalties to add, a violation of any commission, rule, or order, and then we could establish a civil penalty range. I believe the max would be $1,000 for that, but per violation. But
So the answer is yes, and we can even clarify it more if the commission so chooses.
Err on the side of being more clear.
okay, I can add that into this.
That'd be
And that's something that they had added recently on their amendments. Like I said, you see the list here that we've got by each statute. At the bottom of theirs, it states any commission, rule, or order instead of a specific statute, and then it sets a civil penalty range, and then we could just do $0 to $1,000 like we did for the other
All
ones.
encompassing.
And that way, this proposed rule where it says that it's required you notify within 10 days, that's a commission rule at that point once it becomes effective. And if you want me to add that to it, then I can add that to this draft.
three of us saying yes, so.
Okay.
All right, Donna, do you have your complaint comparison report?
I believe that was the last, I'm sorry. That's the last thing on mine, isn't it?
Yeah.
The reciprocity.
Yeah, I can go ahead and go over that now if you'd like for me to. This is kind of a similar topic, and it's something they may or may not want to be added in. Last meeting, you all, when we discussed the issue of the additional continuation, additional continuing education for Kentucky, you basically told me, see how we can do something about this. What can we do? And I spoke with it about it with Mark as well as Chief Counsel Michael Driver about it. And what we came up with is, and is it in their binders?
Right behind the legal report.
Right behind the legal report, under
Tab 7, I think.
tab 4, tab 4, tab 3.
I think it's tab 7 is what I've got. It says current law and rule concerning
No,
non-resident.
it's under tab 4, and it's the last page. In mine, it is.
Oh, okay, reciprocity.
Where it says reciprocity. Basically, when we do anything that affects anything outside of administrative procedures, when it affects licensees or the public, things need to be done by rule. And there's also an issue of notice. So, let me grab. I worked on this rule draft to add in possibly with these other rules that we would be beginning the formal process of next month. For one, the first section just clarifies something which we already have statutory authority to do and that I understand staff is doing, but lays it out again more clearly, which I think has been our recent approach of clearer is best, laying out the reciprocal license fees. But subsection 2 is something that we've worked on a draft of to apply to this and any possible future situations of this type that come up where we're not being merely reactive to something that comes up, but we've already got a rule in place. And basically what this states is, not specifically applying to Kentucky, that if a reciprocal state requires additional continuing education as a prerequisite to licensure or as a prerequisite to licensure renewal, that this commission will require a course of the same number of hours and same or similar subject matter, which will then, we will of course have to work with the education provider to get approved a specific course. But this lays the groundwork for situations like this that could come up in the future. It also, the benefit to a rule is allowing notice, that this is something we're going to be doing. And so this is just a draft of something that I'd worked up. I wanted to share it with you. I told you I'd come back this month with something. After speaking with Chief Counsel, it was believed this was probably the best course to proceed along, but we can of course discuss it. I just wanted to have something for you all to review.
Just as a general comment I'd like to make, I see this going on between the real estate commissions, between the states, and auction commissions and other commissions, and there seems to be and especially between Tennessee and Mississippi, there becomes a big rub. And it's like, well, you guys, y'all stepped on our feet, so we're going to step on your feet, And I hate to see Tennessee become that state that is reacting to what's happening to our applications in other states rather than just doing what's good for us. And, if we need something to make sure that we have people come into this state to get a license, I don't care whether it's a real estate license or an auction license, it doesn't need to be, we're going to be as equally tough as they are just because they decide to be. I mean, I'd like to see us adopt rules that fit within what we really are trying to establish for the protection of the consumer here versus who can equally be as tough as another state. I mean, I hate to see us get into that war between our commission and their commission, and that sort of thing. That's just my general feeling about things, right or wrong. I hate to see us get into that.
And the reason for me drafting this was last month the feeling was we want something requiring the same thing of them, and I thought it best rather than doing something specific to the situation to have something that could address it in the future. But I see your point of view as well, and that's of course something for you all to discuss. That was the reasoning behind this.
Other commissioners may feel differently. I know because I'm in Memphis, I have to deal with Arkansas and Mississippi on a daily basis. Everybody seems to try to make it more difficult for people from Tennessee now. I mean, even Florida has dropped their reciprocity from a real estate standpoint with Tennessee.
Real estate has ended all their reciprocity agreements, and now it's more of a license recognition type of thing.
Got to reapply it in every state now.
Well, what this basically states is that if, I don't want to use a state as an example, a state other than Kentucky, if some other state comes to us saying, we want you to do 3 extra hours every time, it would be presented to you all, and it appeared to me, and I may have misunderstood, that your stance was after what Kentucky had determined that they should have to do the same thing in our state. And so I tried to draft this broad enough to address that all in the future. But if you're indicating that maybe you don't want to require that of anybody else, then this may not be the way to go. I was just trying to anticipate situations like this which could arise in the future, in which case we have a rule in place saying you're going to have to take this amount, and then it's just a matter of gathering together and getting an approved course to meet similar requirements of that other state of what they're requiring.
License so much whenever, because I was in that meeting. Heard of it, but
well, I think it makes it very difficult on the staff to figure out, well, where's this person applying from which state? Now, what rule applies to that state versus, I think we just ought to have a consistent policy of what the requirements are across the board. Either it works for you or it doesn't work for you. If we're going to be the highest one or the toughest one in the South, we need to be consistent with every state, not change our rules depending on what state they're applying from. That's my concern.
And right now, we do have a rule which, states what you need to have to get a license in this state. I think this was just addressing the situation of when they require more, and that may not be something that you all want to do by rule right now.
I'd be against singling out a state myself.
Well, if you go get a fishing license in North Carolina, they charge you now, isn't it? That,
it is.
And if you have the rules of
I think, Commissioner Morris, you're responding more to subsection 2, not the fees part, though, right? Because that's the fees part is currently what we're doing, and we do have a statute that gives that authority. This just lays it out a little more clearly, where if somebody wants to ask about it, we can point to it. I think your concern was with subsection 2 with the additional education requirements. Is that correct?
What do y'all want to do?
I can scrap it. It was just a draft. I was asked to come back with something, and this is what we thought was the best. If you all have further guidance, I'd be happy to keep working on it, and we can keep the first part of this rule if you like the way the fees are laid out, and put that in with the other ones, and just not put in subsection 2 at this time. It's up to you all. It's just a draft. It's Well, we have a statute that gives you all the authority to impose any fee or licensing requirements on applicants for licensees from a reciprocal state that the reciprocal state imposes on Tennessee licensees. So that generally says this. We just thought it might be best to make it a little more clear if we were going to do a reciprocity rule. But there is authority to do it. It's just it sets it out a little more clearly. Well, the other is not a rule. That's actually a statute. It's found in 6219-118, which is the reciprocity statute. I just took that subsection of the statute and attempted to clarify the authority,
So
which,
regardless of whether this passed as part of the rules or not, we still have the statute.
as far as the fees, yes. Yes, sir. It's just a matter of if you do want to clarify it more. It was just something that was brought up, and I thought while I was drafting a reciprocity rule, it might be something that, if there was any confusion, it does pretty clearly lay it out. But if you think the statute's sufficient, that's of course up to you. It does exist, and it will remain there as long as it.
I agree with both Jeff and Marvin, but I kind of come down on the side. I think the reason I come down on the side of Marvin is I think they know that we're not going to do anything. All these other states could get out of control and put in anything they wanted to, so this is more a buffer to keep them off of us and to where they might rethink any.
I talked to a commissioner from Mississippi a few weeks ago. I met him, and he is kind of, these guys are, it's out of hand, and he suggested that some of us come to their commission meeting and work out these fees and get it back to where, we act like civilized grown.
Well, I'd be glad to make a motion that they come up here and do that. That's exactly right. They would not come up here and meet with us, and Charlie Yont and I had to drive to Memphis to meet with them, and they told us we will do.
One suggestion, since Julie's going to be drafting the other rules in a form and bringing it back, go ahead and draft that rule in the rules, allow y'all to think about it individually, and then you can always cut it
We can still cut it at that point. We're still in the preliminary. This is just starting the formal part of it next time.
Why don't you do that then?
Just put it in there and we can discuss it further
then.
then.
We can look at it later and see what we want to do.
That's fine. I just.
There's nothing in this that could make a state think that somebody.
Right, the statute still governs it, and the statute, specifically states that that the non-resident auctioneer or apprentice auctioneer is domiciled in the other state. Is that what you were asking? That's still in the statute. This is just to try to address two of the issues.
Okay, so you're going to draft it up, and we can decide later.
I'll put it in a better
whether we
form.
keep it or not. Comparison report.
Yes, tab 5 is your monthly complaint comparison report with the top grid showing May the 2nd of 2012 with your pending complaints. There were 72 pending complaints. Over the benchmark for closing or resolving the complaints. The bottom grid, 5/1 of this year. $46 over the 100, maybe. I don't know.
How many of those are that one case?
40, right at 40.
Okay. So we've got a net 6 complaints that are over 180 days outside of that one case. When is that case going to go away, do you know, or what's going to happen with that?
Who knows?
I think it was, Adrian reported to me that it went April before the chancellor, and the chancellor granted him a continuance, and I don't know when it was continued to. We were surprised that the chancellor granted him a continuance, but he did. So,
because it was a year ago that they were going to have the formal hearing here, right? Yeah. Or 2 years ago, I guess.
Is that being tried in this district, Chancellor here, or?
yeah, Middle Tennessee, or Nashville, Davidson County.
Additional information on that particular gentleman. Filed bankruptcy. There was one, not a complainant, but a client, former client, that filed with the bankruptcy court to be taken out of the bankruptcy, what do you call it?
Claim, remove his claim.
For $90-something thousand. So I had to go up to court and testify to the license standing and all that, and the judge has taken it under advisement as to whether to release from his bankruptcy claim this one particular vendor. And so Adrian checked on that Friday and said that it's still, the judge had not ruled on that yet.
Donna, what are the typical, the predominance of complaints? What kind of complaints are you getting? Are they about advertising or being unlicensed, or what are they most?
From him?
No, just in general.
It's advertising violations. It's reports of unlicensed activity. That's basically it. And a lot of them are anonymous. They just fax us the ad. And they'll either circle the license number or they'll say violation of whatever. So
we're not getting complaints of fraudulent activity at an auction primarily. Not many of those.
Most recently, as you've seen on my legal reports, it's been most of the others, and I think I've got a couple more where there appears to be a group that are filing them against one another at this point. But they come in ebbs and flows. But that's what I've seen most recently.
What happens to the newspaper ad that is a violation and it's anonymous?
We process it.
Okay.
I meet with Julie, we look at it, do internet search of the auctioneer and the auction firm or the non-licensed auction entities.
Yeah, we look into it to see if. Sometimes with the ones that are sent, there have been some that we've gotten where there's no information and we can't figure out if there is one, and without having a contact, those we put on hold. But if we can determine there's a violation, it's opened as a state complaint, and we do our best to investigate those.
Budget report, you'll see the first report in your packet is the revenue comparison report by fiscal year. That right-hand column shows you the fees that we've received and where they came from since, this is through February. That is end of March. I think Susan copied the wrong report to you, but it's supposed to say 3/31 of 13. But the right-hand column shows the fees and where they're coming from.
Well, the renewals are way down, aren't they?
Well, we're not at the end of the fiscal year yet. This began July 1 of June 30 ends the fiscal year. So.
Don't you have renewals every month?
Yeah, we do. It's on a rotating basis every month. So, but again, there's a month. This is a month behind. You should have had the 3/31/13 report. The next page over shows you the expenditures, and at the bottom, the revenue shows 210,000. But so that other report was a month old. But on the expenditure report, the right-hand column, shaded blue, shows you that that information is through 3/31 of 13. Shows you the expenditures, salary, payroll, expenditures for a total of $112,669.27, with the net revenue reported of $210,412. That's just through March.
That is through March there, is what you're saying.
That's through March. The next report over is, and we didn't get this one in color to you, but it's also through 3/31/13. This is your Education and Recovery Fund fees in the top grid, and the expenditures in the bottom, showing that the fees you've received in Education and Recovery through 3/31 was $53,050, and the expenditures for third-party professional administrative services, that's of course for your continuing education newsletter, $34,693 through March 31st.
What is our statutory requirement for having a balance on our recovery fund? Isn't it $250,000? 150. Okay, so we're above that.
We are above that,
Okay.
and we were in 2011. So the only other thing I have, and probably need to ask you to table this discussion, is on the reciprocal agreements. I have so far obtained 4 or 5 agreements from the other states that we have reciprocity with, thinking you might want to look at them. Some of them are really old agreements, like one was from 1967, I think. If you want to update those, make them all uniform, I'd like to wait and try to get all of the agreements that we have with all of the states.
They're trickling in.
Yeah, they're trickling in. And so
And you think you'll get them?
I think I'll get them. If not, I'll call the directors and see if they'll scan them to me. Some of them don't have them. Like Kentucky, they don't have their agreement, and I can't find Kentucky's agreement. In fact, I don't have any. I believe all of the reciprocal agreements that you'd worked out with the other states over the years was lost in the flood. They were stored in our storage underneath the building over there. So I don't have any of them. Kentucky couldn't locate theirs, and there's another state. I can't remember now exactly who it was. Couldn't locate theirs, so we can talk about this today if you want, or we can wait and talk about it when I get as many as I can possibly get.
Well, we're going to skip a month, so you'll give you 60 days to get the rest of them. Maybe we could do it in
We'll get
July.
a motion to table this and let Donna see if she can accumulate some more.
So moved.
Second. By Howard, all in favor?
Aye.
Is there anything else anyone would?
We are moving. Our offices will be in this building the next time you come in for a meeting. We'll be on the 4th floor. They're moving today. The attorneys are already here. Just moved them Friday. Their offices are stacked high, I'm sure. Haven't even unpacked yet. But no more business in that building.
So we're not going to meet in June.
No, that's Paris Landing.
Convention line.
Yeah.
Right, we do not have a meeting in June.
Y'all are invited.
Oh, can we take these with us to read these agreements and everything?
I would rather you not take the entire book. You can take out the reciprocity agreement. Susan kind of holds on to those books so she can give them back to you and replenish them at every meeting.
I hear a motion to adjourn.
So moved.
Second. All in favor, stand up.
I think I'll wait until you get them all, then I'll look at them.